Hello, this is UCL Uncovering Politics, and today we're looking at free speech on social media. Where do the limits lie, and what should be done when they're breached? Hello, my name is Alan Renwick, and welcome to UCL Uncovering Politics, the podcast of the School of Public Policy and Department of Political Science at University College London. Talking with each other about matters of politics and policy is an essential part of democracy. And today, much of that conversation takes place online through social media. The digital revolution has given voice to millions of people who previously had little chance to be heard beyond the dinner table or the pub or the local town hall. That has great benefits, opening up the democratic conversation to much wider participation. But it also has costs. Misinformation, hate speech, and words inciting violence can all rapidly spread. That raises big questions about how speech online should be regulated. And if it should be regulated more, who should set and enforce the rules, the state or the social media companies themselves? Such questions have been cast in yet starker relief by events earlier this month in the United States. Is it right that Donald Trump was banned from Twitter and that Parler, the alternative to Twitter that became popular on the far right, has been squeezed from the internet by service providers? Well, here to explore these and many more questions is my colleague, Dr. Geoffrey Howard, Associate Professor of Political Theory here at UCL. Jeff's 2019 article, Dangerous Speech, has just been awarded the Fred Berger Memorial Prize by the American Philosophical Association for the best article published on the philosophy of law in the last 2 years. He may be familiar to some of you from the airwaves, having been a new generation thinker in the scheme run jointly by BBC Radio 3 and the Arts and Humanities Research Council. And he currently holds a Leverhulme Trust Research Fellowship, examining how online dangerous speech can and should be limited. Jeff, congratulations on all of those accolades and welcome to UCL Uncovering Politics. And can I just begin by asking you a question that once is specific to one case, but also very broad in its implications. How should we assess, how should we go about thinking through whether it's right that Donald Trump has been removed from Twitter?
Well, thanks so much, Alan. It's really great to be here. I think the general issue here is whether Twitter is right to remove speech and speakers who violate its rules against glorifying violence, even if they are influential political persons. It certainly was Twitter's policy against speech glorifying violence that Donald Trump was deemed to violate that ultimately got him kicked off the platform. And my view is that Twitter wasn't only within its rights to do this. I think that the social media platforms actually have a moral responsibility to remove this kind of dangerous content and to punish persistent violators by temporarily suspending them from the platform.
Let's just unpick some of that. What do you mean, first of all, by dangerous content?
So I think we all have a duty to refrain from speech that endangers others. And this is traceable to a pretty big moral obligation that all of us have. So when I speed in my car for no good reason down a busy road, I commit a wrong against everybody I might hit, right? Simply by subjecting them to an unacceptable risk that they might be harmed. And I think that's true even if, thank heavens, everyone manages to get out of my way. My idea is that this general principle that we all have a duty to refrain from endangering others unless we have a darn good reason for doing so doesn't simply apply to actions like these. It also applies to our speech. So that's what I'm talking about when I'm talking about dangerous speech.
And how do we know what speech is dangerous? Potentially all sorts of speech could be thought dangerous by someone or other. How do we define what is dangerous here?
Well, one thing to say is that at this stage of the analysis, we're simply in the domain of ethics and moral philosophy, and we're asking what kind of speech is morally objectionable, such that a person should take themselves to have good reason to refrain from expressing it, and such that other people should feel justified in condemning or blaming that person if they engage with it. You're right that these questions about whether we should trust authorities and so on arise when we're turning into the domain of political and legal philosophy, and we're asking what kinds of rules and institutions we should set up. But already just at this moral level, I'm talking about speech that risks inspiring unjustified violence. That's really the kind of speech at issue here. Now, speech might risk inspiring unjustified violence by explicitly advocating it. We might think here of speech that directly encourages the commission of terrorist attacks. But we might also include speech here that promotes or justifies violence, even if it goes short of explicitly encouraging it. So, for example, hate speech that demeans members of certain groups as inferior or threatening, and so deserving of harm, might also, I think, does fall into this category of dangerous speech. Now, to the example you raised at the start, Donald Trump's speech fell short of explicitly encouraging individuals to storm the Capitol, but it did in the context of a country in which it is widely believed that violence against an illegitimate government can be justified, stir up that kind of anger and fomented that kind of agitation that was likely to lead to some kind of violence by constantly pushing the lie that Joe Biden lost the presidential election. And indeed, it was after the Capitol riot that Trump incited, that Trump persisted in using language that described those who stormed the Capitol as patriots by continuing to deny the legitimacy of the inauguration of Joe Biden, that finally moved Twitter to ban him from the platform, not for explicitly encouraging violence, but for glorifying it.
So can I push you a bit further there on just what the limits on the dangerous speech are? What about cases where we might think that there's justified violence against an unjust state, perhaps violence against the apartheid state in South Africa? Do your strictures suggest that that kind of speech is also unacceptable?
So no, I think that there are cases in which violence can certainly be justified, both in the interpersonal context and politically. So I think that there can be such a thing as a just war. And if you advocate for that just war, you are, in a sense, explicitly advocating violence. And yet very few people would think that you are acting wrongly by encouraging the government to declare war on Nazi Germany and participate in hostilities in the Second World War. So clearly a moral account, you're absolutely right, needs to distinguish between cases when violence is justified and when violence is unjustified. Simply at the level of morality, I'm saying that in cases when violence is unjustified, it's wrong to advocate that violence. Now, that raises this very thorny problem when we're interested in writing sensible laws, that if, for example, you legally proscribe all speech that advocates the use of force, even in cases when the use of force is justified, that kind of a law would be, as the lawyers say, over-inclusive. It would rule out more speech than is actually illegitimate. So one question here is whether we could, at the level of lawmaking, we could design more narrow language to specify the legal duty to refrain from dangerous speech. So countries like the United Kingdom, I think, try to do this by banning speech that incites terrorism, banning speech that incites racial and religious hatred that might therefore contribute to an atmosphere in which violence is encouraged or tolerated. Now, these might be accused of being still over-inclusive in their own ways, but I think your point is exactly right, that it probably would be a mistake to author a law that made it a crime to ever encourage the use of violence at all. The real task is to figure out what kinds of more limited rules could be appropriately justified. But I don't think it's a hopeless task.
Okay. First of all, you're saying that what Donald Trump said he was wrong to say, in the sense that he did a wrong to other people, essentially, by saying these things and putting them in harm's way. So he had no right not to be stopped from saying that, if you like.
That's right. That's right.
Does anyone else have a right for him not to be stopped? Do we do a wrong to the democratic society as a whole by kind of preventing this kind of speech from being out there and being able to be exposed to these kinds of arguments, I guess?
So one of the most familiar and pervasive set of arguments in the free speech literature appeals to this idea that even if speakers don't have any moral right to express terrible views, dangerous disinformation, hate speech, terrorist propaganda, you would wrong individuals in the broader democratic society, prospective audience members, by suppressing that speaker's thoughts. And one way of formulating this idea, made famous in an early article by the philosopher T.M. Scanlon, appealed to this idea that we have duties to respect the autonomy of listeners to decide for themselves whether a speaker's ideas are good or bad, whether a speaker's ideas are worth acting on or worth instead rejecting. And for the government to ban speech on the grounds that citizens just can't be trusted to hear it because they might go do something bad if they were exposed to it, is just incompatible on this argument with a view of adult citizens as people who should be treated as capable of making up their own minds on such questions. And you could certainly imagine a variation of this argument applying even to the social media platform, saying that if their intention is to curate a wide-ranging and open and inclusive public debate of autonomous citizens, it's incompatible with viewing your users as adults capable of making up their own mind to decide ex ante which ideas are just too dangerous to expose them to. Now, I think this is a really powerful argument, but I think it would be a mistake to grant it a kind of absolute weight such that it defeats any countervailing consideration. Imagine someone in the midst of the 1994 Rwandan genocide had responded to an attempt to limit anti-Tutsi hate speech by making the argument that it was really valuable for people to have access to this hate speech, that it respected them as capable of making up their own minds about whether this hate speech was justified. I think even if it's true that there is some value in being exposed to dangerous speech, because it helps us make up our own mind about why exactly we disagree with it, we have to weigh that against the actual harm to life and limb that the speech could inspire. And in context where the speech is genuinely dangerous, I think this interest we have in being exposed to it so that we can make up our own mind for ourselves is real, but it needs to be weighed against these countervailing considerations. It doesn't have this kind of absolute status.
So Donald Trump is not wronged by being banned from Twitter. No one else is wronged by him being banned from Twitter, at least directly. Might there nevertheless be an argument that banning him from Twitter just actually does more harm than good? I mean, it's not a good idea, ultimately. It's just going to encourage his followers to become even more entrenched in the view that the system is working against them and they need to do something decisive in order to break it.
I think that there is this duty to refrain from dangerous speech. The right to free speech, properly understood, is limited so as to be compatible with this duty. So I don't think the right to free speech protects speech that endangers others in the ways we've been discussing. But it doesn't follow from that we should legally enforce this duty, or even extra legally enforce this duty via the social media platform rules. That will depend on showing that it's necessary to enforce this duty. That is to say that there are no better ways of diffusing the danger of this speech. That would depend on showing that enforcing this duty doesn't have any sufficiently counterproductive consequences. So if banning Trump's speech resulted in his followers becoming far more agitated and more likely to engage in violence than if they hadn't banned his speech, then I think that's clearly an important consideration if the aim is indeed to reduce the prospect of violence. And I think those questions take us into some thornier empirical territory about the effectiveness of these kinds of restrictions on speech. I'm more optimistic about the effectiveness of these kinds of regulations than most, but I grant you that it's not a straightforward issue, that we do need to look at the evidence in each case.
And why are you more optimistic than many?
There is a very familiar kind of pessimism about the inability of speech restrictions to make any practical difference, especially among First Amendment scholars in the United States of America. And their argument typically fastens on the idea that we are just bound to enact excessively sweeping, counterproductive restrictions on speech that are bound to chill public debate and undermine a system of free expression. When I look at countries like the preponderance of the world's liberal democracies, like all of the countries in Europe, like the United Kingdom, like Australia, like New Zealand, like South Africa, that have enacted restrictions on various forms of dangerous expression, like hate speech, I don't see a huge body of evidence suggesting that public debate is radically chilled in these countries, that lots of legitimate speakers are afraid to express themselves. Nor do I see a huge body of evidence suggesting that these laws have been deeply ineffective at making some dent in the amount of hate crime and violence that occurs. Now, that second issue is going to be extremely thorny and is, I think, an ongoing project for empirical scholars to actually try and measure what are the different effects of these different restrictions on speech in reducing violence. And I think it would be fair to say that the empirical record on that is unsettled. So we don't have absolute confidence that enacting laws restricting terrorism definitely reduces the rate of terrorism. But the question then is, if you're a legislator or if you're indeed an executive of a social media company who is faced with this dangerous speech, given the uncertainty about whether restricting it will work or not, is it justified to try to make some difference by restricting it? And my inclination there is that yes, it can be justified to try to reduce the prevalence of this violence by taking action against the speech that we know inspires it.
So does that imply that your view is that we can quite clearly answer the question, was Twitter right to ban Donald Trump, with the answer yes?
Yeah, that's right. So I think Twitter was right to ban Donald Trump. I think, in fact, that social media companies that don't take action against this kind of dangerous speech are vulnerable to a charge of complicity with that speech. If I'm curating a conversation and people are hijacking that conversation in ways that foreseeably lead to violence, and I have the power to try to make some difference in stopping that violence, and I decide to do nothing, I think that I am, in a sense, complicit in that violence.
Twitter also has a duty to consider whether the actions that it takes in response might actually do more harm than good.
Absolutely. So I think you can get the presumptive argument for restricting this kind of dangerous speech off the ground. The full argument, the all things considered justification for doing it, does depend on questions like, will it do more harm than good? But let's examine the Trump case in more detail. Did banning Trump from social media do more harm than good? It's not obvious that it did do more harm than good. And here I think it's important to remember that even if restrictions have certain collateral consequences that we dislike. For example, banning Trump from Twitter might alienate his supporters further. Those collateral consequences don't settle the issue. It might be that those were just unavoidable collateral consequences in achieving our main aim, which was reducing the risk of another serious violent attack of the sort that could have happened on Inauguration Day. And it seems at least plausible that shutting Trump, at least temporarily, out of the public domain so that he couldn't incite violence on social media might have made some difference in motivating his supporters to stay home and not bother trying on Inauguration Day.
Would it be fair to say that there are kind of two possible responses to dangerous speech? One is banning that speech, and another is engaging in what you've elsewhere referred to as counter speech. So we respond to the dangerous speech by trying to counter it, diffuse it in some way. How should we view the kind of relative merits, I guess, of these two different kinds of response?
So it's a very familiar and long-standing idea that the best way to deal with speech you don't like isn't to ban it, but to argue back against it. And this tradition of counter speech is celebrated in the jurisprudence of the U.S. Supreme Court. Justice Louis Brandeis is most famous for articulating this idea that the best way to deal with speech that we regard as dangerous is to vigorously engage with it. And at first glance, the idea of counter speech is a quite promising one, promising because it relieves the state and relieves social media companies of having to tackle the thorny questions about where exactly to draw the line on these various categories of dangerous speech. If we simply permit it all and then say, right, the solution here is to encourage others or to ourselves engage in counter argument against this dangerous speech, then we might hope to achieve at least two goals. One goal might be indeed to change the hearts and minds of those propagating the dangerous speech. So perhaps by engaging with those who are spewing hateful conspiracy theories and dangerous propaganda, we might stand some chance of convincing them to abandon those false beliefs. But second, and probably more likely, counter speech might stand some chance of influencing the susceptibles, the people in the middle who aren't sure what to think, that are exposed both to the dangerous speech and are sympathetic to it, but aren't entirely sure. And it might be those people caught in the middle, the kind of reluctant, susceptible actors who can be reached through this kind of counter speech. Now, when we're deciding the relative merits of counter speech versus censorship, I think one of the questions to keep in mind is one of necessity. So there's a basic idea in the ethics of war and self-defense that you should only use force when it's necessary to use force. That if a policeman can stop a perpetrator by convincing them to put down their weapon, they should try that first, right, before they use violence against that person. And indeed, if they use violence, they should use the least amount of violence necessary, right? They should shoot them in the leg rather than shooting them in the chest. And so this idea, I think, is a deeply resonant one, that authorities should use the least amount of force necessary to achieve their end. And if we can attenuate the danger of dangerous speech just by talking, then clearly that's preferable to the use of censorship, because it doesn't require actually disrupting anyone's autonomy. In fact, you might even think that counterspeech is uniquely suited to respecting our fellow citizens as autonomous, because it tries to eliminate the danger of dangerous speech by appealing to people's rational and moral faculties. And there's something respectful about trying to undermine dangerous speech through this method. So I think it's an alternative well worth considering. I'm not entirely convinced that it's going to be the sole solution, but I think it's definitely going to be an important part of the package.
Okay, I'd like to explore that a little bit further in just a moment. But before we get there, let's just pin down the kind of responsibilities of the social media companies just a little bit further. It's often said that the social media companies are mere platforms. They're just providing a space in which people can publish their views. They don't have responsibility for what is said there, and therefore they shouldn't be held responsible. How do you respond to that?
So I think one way to respond to that would be to challenge the premise, which is the premise of those who are insisting that because social media networks are mere platforms, they don't have substantive responsibilities. To which my response is, why not? What is it about being a platform that means that you're not at all responsible for what takes place on that platform? And here, I think we'll perhaps talk about the regulatory issue in a second, but the proposed legislation in the UK to deal with social media companies is very much based on earlier ideas about health and safety legislation, and the idea that if you're curating a particular space, you have a duty of care to those who use that space to make them safe while using the space by implementing the right processes that reduce the risks that harm will befall those in your space. And I think there might be some problems with this way of framing it, but it does suggest that merely because you're running a venue that we call a platform, it doesn't immediately follow that you don't have any obligations whatsoever. And I would certainly argue that rather than think of social media networks as publishers, as though they were co-authoring or vouching for or standing by the content in the same way the New York Times stands by its editorials or Random House stands by the books it publishes, which I don't think makes any sense when we're thinking about billions of posts put up on social media. The better way is to ask, no, they're not publishers, they're platforms, but they're platforms with public responsibilities. Now, I think that's very quickly, the second thing to say about that is that actually they're not quite neutral platforms, because we know that the business model of these platforms is predicated on the importance of maximizing eyeballs, getting people to keep scrolling, keep looking at content for as much as possible. And if you push content that is emotional, that's politically heated, that taps into prejudices or preferences that people already have, they're more likely to stick around and look at more content, which means more eyeballs looking at ads, which means more money for the social media platforms. And the fact that these algorithms are targeted in this way, for example, we might think of something like YouTube's recommender algorithm that constantly pushes people toward content like the content they've already been looking at, which might be fine when you're looking at cooking shows, but becomes a little more insidious when you're looking at far-right conspiracy theories. So the fact that algorithms play such a large role in determining who it gets amplified on these platforms also should make us doubt the premise, which is that these are merely neutral platforms, like some kind of Hyde's Park Corner where people just show up and say what they have to say, and if people want to listen, they can listen. No, they're playing an active role in pushing particular kinds of content over others. And I think that means that their public responsibilities are even more substantial than they would otherwise be.
And if the social media companies have public responsibilities, does that mean that the state should regulate them and should require them to uphold those responsibilities?
So I think we should be quite open-minded about this, given how early on this phenomenon is and how little experience we have in regulating these strange kind of bodies that are privately owned and yet seem to be the new public square. They seem to be the place where considerable amount of public discourse about our society is taking place. How should we think about the regulation of these online curators, these digital gatekeepers, these intermediaries, however you might want to describe them? I don't think we have a confident view yet about, I certainly don't have a confident view yet about what the right path forward is, but there are at least three different paths we might go down. One path we might go down is that the platforms are entirely self-regulated. Indeed, you might imagine some kind of professional body that all the large social media platforms participate in creating and consent to bind themselves by. So Facebook has recently created an oversight board that will function as its own kind of internal Supreme Court. But imagine some other kind of self-regulating body that all the platforms together were part of, that transparently announced the basis of its decisions. Some have suggested that such a body could even ground its decision-making in some of the precedents set by international human rights law, which does carve out exceptions in free speech for various kinds of dangerous or hateful content. But so far, we don't really see any kind of industry-wide movement on that front, although we do see within particular companies like Facebook the attempt to set up these kinds of semi-independent, more transparent entities. The second approach we might go down is encapsulated by the legislation known as the Network Enforcement Act in Germany, which basically tries to micromanage what is allowed to be said on the platforms. So Germany has essentially said to the companies, listen, you have a duty to take down hate speech on your platforms. Here's the definition of hate speech. And if you don't take down this speech on your platforms, you will be liable to suffer millions and millions of pounds or euros in fines. And so this is very much about regulating the content moderation processes. So again, the second option involves the state telling the social media companies, here's the kind of content we don't like. Here are the performance targets you need to meet in terms of taking this content down. And here are the fines we'll subject you to if you don't. But there is a third way, and I think this third way is best encapsulated by the UK's own new approach, which has been summed up in a online harms white paper that has received a lot of scrutiny and public discussion and will probably find its way into actual legislation over the course of the next year. And the core idea here, and it goes back to that idea about health and safety legislation requiring that people who curate spaces have a duty of care to those who use that space. The idea here isn't so much to micromanage the specific content moderation processes in the platforms. It's not about telling the platforms, here's exactly the speech the government doesn't like that you then need to get rid of or will fine you. It's about working with the companies in the same way a financial regulator might work with the banking sector to implement new practices and new policies within the companies that reduce the prevalence of the various kind of harmful speech. And so this would give the new regulator, which is likely to be, almost certainly will be Ofcom, with the power to work with social media companies to implement and agree upon particular processes to be put in place within the companies to reduce the amount of harmful content that is produced. And one thing that's valuable about this third approach, which has been pioneered by Lorna Woods, a professor of internet law at the University of Essex, and Will Perrin, who's a Carnegie UK Trust Fellow, who wrote this Carnegie paper that looks like it influenced the government's thinking on this quite a bit, is that it isn't just about micromanaging the specific speech of users. It's about stepping back and thinking about things like algorithms, things like the bigger environment on the social media companies that might actually be encouraging the production of this kind of harmful content, right? Whereas, so in the German approach, it's about playing whack-a-mole with all this harmful content, whereas the UK approach wants to step back and say, how can we require that the companies implement processes that actually reduce the likelihood of this content even being posted by users in the first place? And so I think all of these approaches have their merits. My instinct is to favor the third kind of approach that the UK is implementing because of its systemic nature and its systemic emphasis, rather. But I think that each approach has pros and cons, and we just need to. We'll have the benefit of watching versions of all three over the next few years, and that will give us much more evidence, I think, moving forward about what we ought to do.
It's fascinating listening to you as a political theorist discussing this, because it sounds as though we need an alliance of political theory and empirical political research in order really to get to the bottom of what should we do here. The political theorist can provide us with some foundational principles, but often it's the empirical implications of different ways of going that actually determine which is the best approach. Do we need to? Often political theory and political science, empirical political research, are kind of in different silos. Do we need to speak to each other a bit more in order to get to the bottom of these issues?
Oh, without a doubt. I think that this kind of siloing is deeply counterproductive with respect to the big questions that are facing our society today. And certainly a lot of the best philosophical work that I admire by philosophers like Elizabeth Anderson engages really deeply with the empirical social science and the evidence about what's causing the various social problems we're facing. I would add, to create a kind of trifecta, I would add lawyers to this picture, because I think the empirical social scientists have a huge body of evidence that they can bring to the discussion. The philosophers have the principles. But in terms of how we actually craft sensible regulation and how we actually craft rules that can be implemented by fallible human beings, I do think the lawyers have a particular set of insights. And on this particular problem, I think we probably also need people who are experts in the design of the social media platforms. We need technology experts and even engineers to be part of the discussion, because we have to ask ourselves questions about which of these regulatory approaches are technologically feasible. Now, I think it's a mistake to think that there's some kind of fixed level of feasibility that we can't move through innovation. So it may be that insofar as the social media companies continue to use outsourced workers being paid very little money to sift through a huge amount of content, much of it flagged up by artificial intelligence, rather than bringing their content moderation processes in-house and paying full citizens of the corporations to be doing the work. That, I think, those kinds of considerations will certainly feed into this as well. So we should be skeptical, I'm saying, of claims by social media companies about certain regulatory demands being too demanding. I think what counts as feasible is a function of how many resources are thrown at it. But I think you're absolutely right to draw attention to the crucial claim that no one discipline has all the answers here. And we should be skeptical of people who talk as though they have all the answers on this question, because it is very difficult and it requires real cross-disciplinary engagement.
Well, I think you have certainly helped us get a bit closer in our answers, or at least you've clarified a lot of these issues in my mind. So that's been a really great discussion, fascinating work. Jeff, thank you so much. Great to have you on UCL Uncovering Politics. And those of you who are lucky enough to have a library subscription can read Jeff's article, Dangerous Speech, online. If you go to his website, you can also find a range of other articles, talks, radio pieces, and much more. We'll put some links in the show notes. Next week, we'll be continuing the philosophical theme, looking at what role care should play in how we think about punishment. And we'll be doing that with our colleague, Helen Coverdell. Remember to make sure you don't miss out on future episodes of UCL Uncovering Politics. All you need to do is subscribe. You can do so on Apple, Spotify, or whatever podcast provider you use. I'm Alan Renwick. Our producer is Abby Turner. Our theme music is written and performed by John Mann. This has been UCL Uncovering Politics. Thank you for listening.